All right. I think we're going to go ahead and get started. My name is Cece Schnapp, and I am chair of the Bench and Bar Committee. I am delighted to have you all here today and to make a few announcements and introduce you to our wonderful panelists. For those in the room, we have a few extra chairs up here, so if you see others come in, please feel free to let them know they can grab one. If you haven't already, please see Aaron standing up right there, or Dale in the red coat over here to sign in. And if you want credit for one CLE hour, please be sure to pay your $5. If you don't have it today, Dale will be at 341 on Thursday, and you can bring your $5 then. So without further ado, I will introduce you to our panelists who will be presenting, and we are broadcasting this, so hopefully everyone on the phone can hear, and we'll be putting the materials on the court's website, so please be sure to visit after. A copy of this presentation will be there as long as a recording. So we have Alex Johansson to my right, and Alex received his BA from the University of Tennessee, where he attended on a full basketball scholarship. He received his law degree from the University of Memphis, and he also has an LLM. He is admitted to practice in Georgia, Tennessee, and New York, and has 27 years of bankruptcy experience and has been involved in a number of local and national consumer organizations. He is also board certified in consumer law and a mentor for the Georgia State University's BAT program. To his right, we have Brandy Lassane. Brandy received her BA from Erskine College and her JD from Georgia State University. She is admitted to practice in Georgia and Florida and began practice by representing consumer debtors at Clark & Washington. Since 2008, she's been a creditor's rights attorney specializing in the representation of financial institutions, including banks and mortgage services. She is now an attorney with Barrett, Staffen, Frappier, Turner, and Engel. And to her right, we have Melissa Beatty, who received her BA from Tulane and her JD from Emory University. She is the past chair of a number of organizations, including the Bench and Bar Committee, SmackBag, iWork, and she continues to serve on all of those groups now. She was a partner at Sykes and Harbison, where she represented institutional lenders and other creditors in bankruptcy and commercial litigation until this past fall, when she became a standing Chapter 13 trustee. She is now responsible for administering Chapter 13 cases or plans in the Northern District of Georgia for the Judges Drake, Judge Bezier, and Judge Lisa Richard-Craig. I'm delighted to introduce them all to you today. We have a very educational and informative panel on the new Chapter 13 plan. So we ask also, I know that this is a very hot issue and that there may be a lot of questions. We definitely would welcome hearing from you, but given that there is a lot of material, if you wouldn't mind just holding them, your questions may very well be answered by the panelists as they go through. So with that, I will turn it over to them.
Thanks, Phoebe. Good morning, everyone.
Morning. First, thanks to the Bench and Bar Committee for inviting me. I appreciate that. Just a quick observation. In the short time that we've been under the new rules, I've had several attorneys come up to me and express their frustration and anger at the new burden that's been placed on them for the new service rules. So all I can say is I'm in the same boat, and we'll all figure this out as we go forward and how to absorb costs or pass costs on to the debtors ultimately. I think it's obvious that the postage that you bear will obviously go up, but what I think is a hidden cost or not talked about, overlooked, is the time involved in preparing your certificates, researching who to be served, and filing the certificates. I found in the short time that we've been under the new general order so far is that my time involved far exceeds my cost of postage. So to the extent that's important in your fee structure, keep that in mind. Let me talk about service of the plan, of the initial plan, couple things to be aware of. If you file your initial plan same date as your petition, the clerk will serve the plan for you to all the creditors on the matrix. The same day being defined as up until midnight, the same day of the petition. If you file your plan any other day, any day after the petition date, the debtor or the debtor lawyer has to serve the plan on all the creditors on the matrix. That's a significant cost. So if you want to try to reduce your costs, file, if you can, your plan the same day and let the clerk bear the cost of serving the initial plan. Regardless of who served the plan, the clerk or the debtor's lawyer, if your plan includes a lien avoidance or a cram down, you have to file a separate certificate of service indicating service under Rule 7004. My initial thought was, well, I can just add to the matrix the party under Rule 7004, the registered agent, the CEO of a corporation, for example, and let the clerk serve that, and I would just say the clerk served it. Well, that didn't fly. That doesn't fly. You actually have to file a certificate of service, indicate who you served, when, and what manner. It's important to state the manner of service, whether if it's a FDIC insured institution, you have to serve as certified. So keep that in mind. Regardless of who serves the plan, you may have to file an additional certificate of service if you are cramming down or avoiding a lien.
I can intercede on that too. Mm-hmm. It's really important. If you file the plan, if the clerk hasn't served it initially, you have to send it out to creditors. You have to file a certificate of service on all creditors. Mm-hmm. If you have to serve under 7004, what you file is the certificate of manner of service, and that is the event code that you use. And it's very important that you use the correct event code because that's how the court tracks those 7004 certificates. Yes.
So if you end up serving the plan, you have to serve all creditors no matter what. But there may be additional certificate of manner, as Melissa pointed out. So how can you reduce your costs or keep your costs down? And I don't think there's any way to eliminate or get back to the point we were before December 1st. But a couple things I do, and I've heard other attorneys doing, is two-sided copying. If you have a copier or a printer that will print on both sides of the page, I've learned you can get our current new plan in one envelope with one stamp, if that's important for you or to you. Some attorneys reduce the fonts, just as long as it's legible. I assume that's okay as well. Obviously, another way is to serve your plan or file your plan the same day as your petition. That could be a huge cost. A potentially third way to save costs is use electronic service where that's allowed. All I can tell you is that the Bankruptcy Rule 9036 allows electronic service with the consent of the creditor. So to the extent that our local practice allows that, try to use that if you can. How do you get the creditor's consent? Ask them. I've done it. Look at the proofs of claim that are filed. A lot of creditors have an email contact. Address your email to the person who filed the claim, to the email address, and ask if they'll accept service in the case. Most times, they'll write back same day, say sure. But if you do that, you'll have to indicate in your certificate of service that that's how that creditor will serve. A second way to get a creditor's consent is look at the notices of appearance that are filed. I used to just get these and file them and just note that I had them. I wasn't reading them. But if you read the notice of appearance, it will direct how that creditor wants notice. A lot of them will say serve the creditor at the following address, and it'll be a physical address, and you serve them there. A lot of them will say serve the creditor electronically or otherwise at the following address, and it'll have a physical address and an email address. I would argue that's consent to service by email. That comes in really handy with secured creditors. If the creditor is materially and adversely affected, which we'll talk about, that may suffice for service for that creditor if they're indicating that's how they want to be served. So all of this attempt at saving costs may not be a big deal in one case, but over 12 months or so, I think those costs will add up to a significant savings if that's what you want to do. And I know attorneys are already raising fees to cover their time, but we will figure that out as a course of doing business, how we want to do that. As far as service, just keep in mind, you might want to try to get the creditor's consent.
I just wanted to mention, too, from the trustee's perspective, I don't speak for the court. I don't necessarily speak for Nancy or Mary Ida, though we do try to be consistent where we can. But it's very helpful for us and for everyone if you serve with the mailing matrix, the court's mailing matrix. And ECF's been reorganized lately, some of the event codes, but it's under ECF utilities, miscellaneous, and then it says mailing matrix, and you click on that. And if you use the mailing matrix at that time, it should have every party of interest in the case, including anyone that's filed a notice of appearance. And so that would include everyone. So when you're just doing service of the plan to all parties, that's the best way, to me, to cover everyone, the easiest way, though it may not be the cheapest necessarily.
Well, I think it's also important to download that mailing matrix the day of your service. Don't use one that was filed initially by the clerk. It changes. So make sure you download it the same day.
Yes, Tina.
When you said you take that mailing matrix and make it a PDF to do for the document, it will date it. So you know that is the date he was on at that time. You do it another day, it will have a different date, and if there are people that were added to that.
There's no cost to downloading that, is there?
Just to repeat, Regina, for those that are on the phone, she was saying that when you use that mailing matrix, if you save it as a PDF that date, it will date it so that the document that you have is dated and everyone can see that. I was repeating, just so everyone knows we're broadcasting on the phone. So, all right. I think Brandy's going to talk to us about plan-specific issues. And yes, Nancy.
So also, we have an agreement with my office that if you agree to accept service electronically, we will accept service from you electronically. And so if you don't have that agreement with my office, we would love for you to get on board, and you can just contact us. We just need an email, something in writing that you can send to. And just to piggyback on what Alex was talking about, if you have that agreement where someone is accepting service through ECF, you still have to put the email address or the way and the manner in which they are accepting service. You can't just say, I serve Nancy, ECF or electronically or something like that. You have to have the email address in which they will receive it.
Yeah, you can't say, I serve the following by mail or email and then not specify how they were served, which is what I see a lot, I think.
The way I word my certificates is if I'm using email, I will say I serve this creditor. I'll list the person's name, email, and I'll also note that it was with their express written consent, which if somebody wanted to come back and follow it, I can show that.
All right.
One more thing?
Yep.
The Chapter 13 trustees do not need to be served physical copies. That's the only exception.
Only if you have that agreement.
Right.
Yeah.
I believe we all three accept electronic service, but I can't speak for Marietta. Nancy can speak for herself, but
we accept electronic.
Yeah, we accept electronic service. In fact, I prefer it. All right, plan-specific issues. These are issues, the actual form plan or plan form.
All right. Well, first and foremost, we all have to make sure that the correct form is used. There's been different versions circulated. We all know now that we can't use the old plan or the national form plan, but there's definitely been a couple of different drafts of our current plan. So if you just go onto the court's website under the local forms section, you'll see there the PDF for the most updated version. So to the extent you may have older versions saved on your computer, just be sure periodically that you've got the new form, or the current form, and I know that the announcements go out whenever it changes.
Can I interject here on that? This is a change in our district. This is actually a form now that we have adopted. So it's not optional. Our plan before, our two-page plan, it was an optional form that people could use. It's no longer the case. So you have to use this form. You have to use the right version. And believe it or not, people use different versions of this form or the national form plan still. So.
And to add to that, I mean, as you said, this is the required form, meaning you can't change it. You can't alter the plan language in any way. There's a big blurb on the plan that says if you do make any changes that aren't prescribed in the plan, other than adding non-standard provisions in Section 8, that those sections won't be accepted or won't apply. So again, non-standard provisions, that's where anything additional you want to add, change, it has to go in there. And you have to check the box under Section 1.3 stating that that's included. And again, if you don't, it will not have effect in the plan. And of course, this is a plan of a lot of boxes. There's more boxes in Section 1 for cram down, lien avoidance, and again, the non-standard provisions. Make sure you're checking the correct box. If you don't check a box, well, you have to check a box for each one of those, either included or not included. Make sure if you have a cram down, you're checking the box for 3.2, lien avoidance for 3.4, and then the non-standard provisions for Part 8. So just make sure what later in your plan corresponds to which box you're checking.
And if I could just say on that, you can't check that there's a cram down and then there's not a cram down. We will object to that, all three trustees. And it's just because otherwise it's not meaningful, right? The court wanted those boxes to have meaning, and if you're just checking them every time, then they don't have any meaning. And so we think that we should object in that circumstance.
For the plan payments, this is something that's different from the previous plan with step provisions. In the old plan, when you put a step provision, you could put the amount that the payment was increasing by. Now we've got a little box here that's very specific about what goes in each box and what you're checking the provision that it's there, but then you're also putting what the payment will change to as opposed to how much it's changing by. So rather, if it's going from 100 to 200, you don't put that it's changing by 100. You put that it's changing to 200. I think this has been a big
This is another issue that we see a lot. This just goes back to this being a court form. You cannot alter any word. That means you can't delete the box because you don't like it and free type. You have to use the box that's there. You can't change the language in the box. So I know people in the past are just trying to change it to use the practices that we've done, and I just want to point out that you're not really supposed to do that. So please use the form that's there because otherwise we're going to object.
In Part 2.3, it deals with income tax provisions in the plan. There's a blank there. The only thing that should go in that blank and what should be in there is the specific tax years that are included. So make sure you spell it out, 2018, 2019, put the specific years there. It shouldn't be left blank, and you shouldn't put anything other than the years. And then I'm going to let Melissa cover 2.63 as far as how the trustees are handling additional payments and additional funds.
So I just wanted to mention, if everyone, make sure that you've read 2.6 of the plan. It's the disbursement scheme. It tells the trustees and how the money is to be paid, and it tells you how the plan payments are going to be paid out to creditors. And there's a difference between how income tax refunds and how additional payments as defined in the plan are paid. Okay, those two groups of funds, when we get income tax refunds, those pay off attorney fees first, rather than going out pro rata to the attorney fees and secured creditors that we're paying. So keep that in mind. What I wanted to let you know is that all three trustees, if we receive money, which is not defined as an additional payment in the plan, okay, and I've seen people use this provision to say the debtor will pay their bonuses, they will pay their personal injury proceeds, maybe they're going to sell their house. That's all perfectly fine. But in most circumstances, you're not going to know about these additional payments because they're going to be funds that we're going to receive. For example, we get a lot of money pre-confirmation that come from garnishment, or your client made a payment to the creditor that they received post-petition, so they turn around and send it to us. In those circumstances, all three trustees are going to send you a letter that will say, we received these funds. If we don't hear from you in 30 days, if there's not something in writing or a court order telling us otherwise, we're going to pay that money out to creditors as a regular plan payment. And I just want you to know that because that's how the money will be dispersed, which is different. So you should make sure that you're familiar with that. And if you want to do something else, you should notify us in writing. So just look for those letters. But we are trying to be consistent. And, of course, you can file a motion with the court as well.
All right. Part 3.1 deals with the maintenance payments of secured claims. Remember to put your maintenance payments there for all secured creditors that the debtor's paying direct, even if there's no arrearage, even if there's not any other treatment in the plan, if the loan's current. Those payments still need to be listed there, and that's mortgages, HOA payments, anything that's a maintenance payment. Under that section also has a blank or a box to fill in for an interest rate. It's up to you to determine if there should be any interest, but best practice would be not to leave it blank. If you don't want to pay interest or don't think the creditor is entitled to interest on the arrears claim, just go ahead and put a 0 there. Another change with this plan is what happens when the stay is terminated. As it states in the plan, the payments to the secured creditor terminate when the stay is terminated. This applies to every creditor secured by that collateral. So just because only Bank of America on the first mortgage got stay relief, if there's other claims secured by that collateral in your plan, they're no longer going to be paid. That's the new language in the plan. So to the extent that you need them to be paid, there needs to be some other order or something else needs to happen for that to happen, for those to still get paid.
Just be aware of that. I suspect that this will be litigated. But from my perspective, as the one administering the plan, I don't know how to interpret it, but that if you get a second mortgage, gets the stay list, then I have to stop paying the first mortgage too, and anything else that's in that section that I can identify with that collateral. I believe that my plan is to send out notices to all creditors that are affected, just to say that we're going to stop funding your plan because of this, stop funding your claim because of this, just as a courtesy. That's our plan right now. But just be aware of that. It may be a good idea to serve other creditors if you follow, if that's going to happen. So.
3.2 is your request for valuation. If you're putting a cram down in the plan, be mindful of the box there and filling in the form correctly. For cram downs, just as kind of a general guideline, the amount in the value of collateral box is kind of in the middle there. Typically, it should be the same as the amount of the secured claims. If you're cramming down a car or cramming down a mortgage, what you're wanting to pay is the secured claim, and that's based on the value. So those two amounts should be the same. Also, be aware of when a motion is required. Beware of checking that box, because then, a motion will be expected and necessary for the plan provision to have any effect. But there's a lot of detail about that in the General Order 21-2017. Gives the specifics on, your option and what the effect of filing a motion or not filing a motion. That's sections 3.0 to 3.4.
So if I could say a few things about this. One, if it's a tax lien, it's a governmental unit, you have to check the box. You got to file a motion. The other thing is, I think 3.2 causes some confusion for one reason, because it says it applies to cars that were incurred more than 910 days or more than a year if it's other personal property. But we have an oversecured car. I'm seeing this a lot. You're not really trying to cram it down, right? You want us to pay it in full. The problem comes because now we have these two boxes. We have the value and we have the amount of the secured claim. And you typically don't really know what the exact amount of the secured claim is. We have to pay the amount of the secured claim per the plan. And so if those two numbers don't match because your car is oversecured, we're going to object, just so you know. So the solution to that, and I think all three trustees would agree with this, we're not going to object if you put it in 3.3. If you put it in the non-cram down section, even though you could cram it down, we're not going to object to that because it's oversecured. So that would be my recommendation. If you want it paid in full, you're not cramming it down, put it in 3.3. If something happens later, I suppose the car claim comes in higher, you could move it back. Nancy or Ed, do you guys disagree with that?
You're saying that you would object to 7,004 if they were secured?
No, I didn't say anything about 7,004. That's another point, though. Okay, so there are two issues. There's several issues here. One is, let's say that you're not really cramming the car down. It's the oversecured. It's title match, value 10,000, claims 3,000, right? Do you have to check the box on 1.1 on the first page of the plan saying it's a cram down? I think you do.
Because it's not a cram down.
Right.
It's an evaluation.
Because if you don't check that 1.1 box, then whatever's in 3.2 is not effective. So even though it's not a cram down, I think you have to check the box. Now, the second issue is, do you have to serve it under 7004? I'm not a judge. I don't think you do. But if anyone has any questions about that, I guess we can discuss that with the court. But if you're not really affecting their lien, then I don't think anything requires you to. I'm staring at the judge across the room. I'm not getting an evil eye.
Someone had to Judge Bonfeld at the bench, and maybe you guys were in there. I don't know. I don't want to mistake, but I was told that he said from the bench that he did not think that triggers 7,000 for service. But I wasn't there, and I don't know that.
I will say this. You may get an objection from my office if the claim hasn't been filed yet, because I don't know whether it triggers 7,004 notice until I see the claim to see whether it is turned out. Does that make sense to everyone? So
I also heard we can't quote Judge Bonifeld to Judge Bonifeld.
Yeah, a few times.
Thanks, Brittany.
3.4 is strictly for lien avoidances under 522F. So please do not use this section to strip off junior mortgage liens. Those have to go in 3.2. Also, be sure to use a plan. I understand that motions to avoid lien that shouldn't be filed, that are being filed, are being denied. So don't waste your time with that. Put them in the correct section.
I think you can still file a motion to avoid lien. If for some reason you need a lien avoidance order now, early in the case, as opposed to later, you can still file a motion, take your order, and do what you want with it.
No, I think the court will deny your motion if you file it.
You can't file a 522 outside of the plan. It's just that option on land.
Versus a 502.
For a lien strip, you can, but there's a box to check under 3.2 in this box, but not for lien avoidance under 522.
Now, if there were a post-confirmation situation where something was unanticipated, I don't know how the court would address that, but anything else from that?
All right.
Does everyone notice a new confirmation order come out? So I have a copy of it up here if anyone would like to see it. But what it says is on regarding lien avoidances, unless the court orders otherwise, if Section 3.4 of the plan provides that a judicial lien or NPMSI interest is avoided as of the entry of the order confirming the plan, such avoidance is subject to Section 349 and 522 if the case is dismissed. So it's effective, but if the case is dismissed, it's reinstated pursuant to 349.
All right, 3.5 is where you deal with surrender of collateral. It's important that you list all claims secured by the collateral. So don't just list the first mortgage, list any HOA, second mortgages, or property tax. Also, if you surrender, then the stay is terminated upon confirmation of the plan. It used to just be as to the debtor, as to the automatic stay, but under the new plan, it's also as to the co-debtor stay. Also, if you've surrendered in the plan, but the secured creditor files a claim anyway, we'll do that. It's not necessary to object to the claim. The trustee's not going to fund it.
No, I think that if you don't schedule a secured creditor, but it's secured by that same property, it will not be funded just because of the language in the plan.
That's confirmation, right?
That's a big change from prior practice.
Mm-hmm. Yeah, it's a big change. So, yeah, it is very important that you list all of those creditors. So whenever your client's surrendering a property, as she said, just make sure you discuss with them every creditor that could be secured by them and put them in that section so they have noted.
Don't forget on HOAs that liability can still accrue post-filing unless you can get your client to transfer the property out, just on a side note.
All right. 3.6 is other allowed secured claims. There's a blank in that section where you have to put an amount for the interest rate. I mean, an amount has to be there. You can't leave it blank. It's an interest rate percentage. So practice pointers, you can make sure that it's filled in.
So we object if it's not at least prime. I think that some judges believe it should be a prime plus.
I see 0% most of the time.
So that's why we object. So.
All right. Alex.
All right, Alice can talk about attorney fees. Can I say one more thing on the motions, the 522 motions, go back to that? It's just something to keep in mind that prior to our new plan, when we did 522s, you filed them by motion, and then the court entered an order, and the order said that the lien was avoided to the extent that it impairs an exemption to which the debtor was entitled, right? Sort of a vague order, okay? Order's not vague now, right? And all of it's mapped in the plan. And so you just need to make sure that you have, sorry, I have in the wrong section, that you're doing this correctly, because people are looking at this to make sure that the math is right. So just keep that in mind, because the court doesn't want to enter orders on stuff that's inaccurate. And I know that the law clerks spend a lot of time looking at that.
Attorney fees?
Attorney fees, Alan.
Attorney fees. The general order allows a certain fee, up to $2,500 for dismissal pre-conversion or pre-dismissal. It's a set fee of $2,500 unless you want to recover filing fees that were advanced, and you can request up to $2,810, which is the filing fee, plus the maximum allowed attorney fee. Not a whole lot to say there. I wasn't privy to why that is, but in other words, you cannot recover credit counseling fees if you advance those fees, or credit reporting fees and all the other stuff that some attorneys will try to recover post-filing. I think the reason filing fees are allowed is that Rule 1006 contemplates filing fees being paid post-petition, therefore they can be recovered post-petition. Other than that, just keep that in mind when you're setting your fee limit under, I think it's 4.3, I forget. But whatever your practice is, just make sure you can recover the max, whatever you advance on the filing fees.
So that increased from $2,000 to $2,500 is what it was before, plus the $310. Mm-hmm. Make sure you amend your 2016 disclosure statement, your form, because people haven't done that yet, so that it's consistent with the new amount.
The attorney's fees, the new plan can only be used with the flat fee or the flat fee tied with an a la carte menu, which probably most attorneys do. I don't know of any attorneys that do hourly rates for Chapter 13, but if you were going to do that, it would have to go into the non-standard provisions in Section 8. Just keep that in mind. It should be spelled out there, whatever your rate is. I
do want to mention one more thing under Part 4. It's not on the slide, but DSO creditors are in Part 4, and as I understand it, the court form plan that you can fill out has been corrected now so that you can free type text in that section. I think before you weren't able to do so. So if anyone's using that, you should now be able to do that in the DSO section.
I did overlook the negative notice on fees. If you want to seek additional fees after filing or after confirmation, there is a new form that you can use for negative notice. If you're seeking fees of less than $1,000, you can do this on negative notice now, which works pretty well. You file your notice, you set an objection deadline, and if nobody objects, hopefully you'll get your fee in the next disbursement.
Great. Thanks. Today we're going back to Randy and talk about the rest of the plan.
Part 5 deals with unsecured claims. And again, we've got some more boxes that have to be checked. In this section, you only check one box, and you have to check a box. Here in the materials, we put in, I guess, the cool language of what each section applies to. First box for base plans. Second box would apply if there's a pool. Next is for dividend or for 100% plan. There's no way to kind of do a combination of two or, this. If it's more than this, then this. You have to choose one box.
And by the base, what that really means is that it's a 0% plan unless there's money left over to pay. So it's really a 0% case.
All right. And then direct payment of student loans, how's that handled in the new plan? I don't think there's one answer to that, but look to using 5.2 or 5.3. Just carefully read what each of those sections does. Also, may be appropriate to put it in Part 8 under the non-standard provisions.
I think I've seen it in all of them.
Yeah.
So 5.2 is secure and maintain of an unsecured long-term debt.
Mm-hmm.
So are you really curing it? Probably not, because your client's probably not current. But
it probably won't be done by the end of the day. Well, I guess it would.
But otherwise, it sort of works. So anything else on that?
No. And then just to circle back again to the non-standard provisions, bankruptcy rules 3015C says that non-standard provisions must be in Part 8. Remember again that the box in Part 1.3 has to be checked, included. There are some potential things you should not do in Part 8 that we've seen. That's not where you stick the lien stripping language, like with the old plan, how you put a paragraph near the end. It doesn't go in Part 8. It goes in 3.2. Lien avoidances go in Part 3.4. Also, this isn't where you should put, like on a mortgage that's current, that's not where you put they're going to be paying the mortgage direct. That needs to be in the maintenance payment section.
And that's really a practice pointer, because you want the rest of that language that's in 3.1 to go with your mortgage claim, right? So what I've seen people use 8.1 for, direct payment of student loans, direct payment of co-signed debt, mortgage provisions that say that the creditor has to apply the payment based on the note in the security deed. Whether that's necessary, I don't know. But anything else you guys have seen? Those are the most common ones. But all right, that's it. All right. So our final section, we're going to talk a little bit about amended plans and the new general order process, which I think there are a lot of questions and concerns about. So the pre-confirmation modification is what the general order is. General Order 21-2017 provides for the procedure. It's really amendments is what we call it colloquially in our district. If you haven't read the general order, I recommend that you do. It's very detailed. It's long, but it sets everything out in good detail. But basically, it provides for a few things. It provides that we have to use the new local form plan. It gives you an option of using an optional statement of modified plan. It discusses material adverse changes to creditors and then notices of reset confirmation. So when you're filing a pre-confirmation amendment, you have two options, all right? Remember, you file your plan with your petition. If you file it the same day, you don't have to send it out. The clerk will send it out to all creditors, unless you're doing a lien strip or a cram down, and you have to do 7004 service. In that circumstance, you have to file the certificate of manner of service for that creditor, okay? When you do an amendment, sort of think of the same thing. But you have two options procedurally. First, you can just refile the new plan and send that out to all creditors. So you would take the plan form, you would file it with your amendment. Keep in mind that there's a upper right-hand box. You have to check that, and you have to indicate which sections are being amended. And this is very important. You have to include every single section that you're amending. If it's not included, then it doesn't count. But file the plan, put your changes in there, send it out to all creditors. Every creditor gets a copy of every amended plan, okay? If you are changing something with a 7004 creditor, you're negatively affecting them, then they are entitled to get 7004 notice of that, service of that. So you would have to file the plan. You would file a certificate of service with all creditors, hopefully using the court's mailing matrix. And then you would also file a certificate of manner of service for that 7004 creditor, showing that you served them pursuant to 7004. Does that make sense to everyone? All right. Second option, instead of doing the entire amended plan, you can do a statement of modified plan. Now, what this is basically it's an amendment cover sheet. And the purpose of this is so that you don't have to send out all of those pages to everyone. It's to save you money on paper. I don't know if it'll save you a stamp, because I think that you can I think it costs a stamp to send the whole plan out or to send this one page out. But you have the option of using the statement of modified plan. But if you do that, you have to do a few things. First, you have to file the amended plan. You still have to do the amended plan, and you still have to file it as an exhibit to your statement of modified plan. The statement of modified plan has to specify each section that's amended, and it should be consistent with the sections that are in your amended plan that's attached as an exhibit. It has to state that any amendments not set forth in the modification statement are ineffective, and it must otherwise conform with the general order. And here's the form. It's an exhibit to the general order. It tells you what you have to do. My recommendation is if you do this, the best practice is to quote the changes. So I would say the plan payments are increasing from $500 a month to $600 a month. Or the payments to ABC Company in Section 3.3 of the plan will change from and then to. Though I guess you could just put the to and just include the box. But I think you have to be that specific, okay? The problems that we're seeing is that people are not including everything that they're changing. They're not being specific. They're being very vague. And I don't think it's effective notice. The way to use this effectively is you have to be specific, and it probably only works best if you have very simple changes to your plan, right? Because otherwise it's just going to be a lot of work for you to figure out what you have to quote. I mean, it may not save you paper, but it is an option that you can do. But remember, you have to still follow the plan. It has to be an exhibit to your statement of modified plan. And if, sorry, go ahead.
I was just going to say, since you have to file the plan either way, a lot of attorneys have told me they're not going to bother with the statement of modified plan because they have to match exactly. So if you file the statement of modified plan, you've just increased your odds or risk that they don't match and something's going to be ineffective. So if you do that, fine, be careful.
And that's what we're finding is that they're not consistent. But just to summarize, what must be served? If you file the statement of modified plan, then you only have to serve the SMP to all creditors and not the entire plan. If you file only the modified plan without the SMP, then you only have to serve the plan itself, okay? Who do you serve it to? You serve it to all parties in interest. Every amendment goes to every creditor, okay? Whether or not they're effective, they still get notice of the amendment, okay? But they don't have to have 7004 notice, and they don't have to have the notice of reset confirmation, which we'll talk about. And you have to file a certificate of service promptly. That means within 3 days, as I understand, in the court. For what Judge Bonnefeld said at the CLE. Now, 7004 service. If your plan materially and adversely affects a creditor who has to be served under Rule 7004, you have to serve them under 7004. And so you would have to file a separate certificate of manner of service for that one creditor. So you have a COS for everyone else and then a CMS for that one creditor. So, all right, so let's talk about material and adverse changes, or MAC changes. I think Judge Ritchie Craig came up with that, so you can thank her. All right, so what is a material and adverse change? All right, so this is according to Melissa Davey. It's an explicit negative change to a creditor. That's how I view it, okay? If you explicitly change a creditor in the plan, if you lower a plan payment, if you lower an interest rate, if you lower a set payment, if you delete their treatment, then that's an explicit negative change, and that requires additional notice, and we'll talk about that. What about first-time treatment? What if you've never treated a creditor and this is the first time you treat them? I don't know that the general order says that that's a material and adverse change. I consider it to be. So I just think that it's a due process issue, so it should apply. Who determines whether a change is a material and adverse change? The court. So if you ever have a disagreement with the trustee or a creditor about that, I guess if the creditor's there, it wouldn't matter, but then, of course, the court, it says in the general order, the court can make a decision about that. We'll determine it. What is required when there's a material and adverse change? A special notice of hearing. And so let's talk about that. This is the MAC notice. So you file an amended plan and you lower the interest rate on a creditor, okay? What you have to do with that creditor is you have to send them a copy of the amended plan, file a certificate of service, and then you also have to serve them a notice showing the time and place of the rescheduled confirmation hearing. All right, are you rescheduling the confirmation hearing? No, you are not rescheduling the confirmation hearing. You do not do it in advance. The court is rescheduling the confirmation hearing in the normal process that we've always done. But once you have that date, then you go ahead and send the notice out so the creditors knows when it's coming back up for a calendar. You have to tell them that they have to file an objection to the plan at least 7 days before the next hearing. You have to give them at least 28 days notice, and there is an a form for this, which is Exhibit C to the general order. And remember, if this creditor is entitled to 7,004 notice, 7,004 service, I think you have to give them 7,004 service of this notice, okay? And you have to file a certificate of service. I don't think you have to file a separate certificate of manner of service for the actual MAC notice. So, does that make sense? This is a copy of the notice, which hopefully everyone is using. It's the form. Please don't use your own form. We've seen people do that. The court has a form. And as I mentioned, there's a new confirmation order, which I have a copy of if anyone wants to see. But I think that's generally what we had, and we'd love to take your questions.
Wow.
Don't be so quiet.
I don't
Yes, Ms. Allen.
I have more of a comment. My name is Leah Allen, for those of you I don't know for operation. So this goes back to the initial plan that was filed. It's really important that you flatten the plan. I think back on 12/2, we sent a message in instructing folks on how to flatten the plan. What does that mean? The plan that we have is dynamic. That means if you click on certain boxes, it'll pull out certain span if necessary. If you don't flatten the plan, then, and if you file your plan in conjunction with the petition, if you don't flatten it, we're not going to be able to serve it. We can't serve it. So make sure that you're doing that, please. We're still getting plans where people haven't flattened them and we can't serve it. It's also modifiable. It is modifiable. We can change things in your plan. Creditors can change. Anyone can change your plan, which is why it must be planned. That's the whole. That's the real purpose.
Does the clerk send out a notice advising that wasn't filed properly?
Actually, there was a notice that I think on 12/2.
Vinny, can you say what flatten? Can you tell people how to flatten?
Sure. Well, the instructions are on the website, so I don't want to mislead. But essentially, I think you go up to the file menu and you print as an Adobe PDF, and that makes it a flattened PDF. I'll start over.
I think it makes it like you scanned it as opposed to it's a PDF that can be edited.
The whole, just to, I guess, start from square one. The plan form itself, the court plan form, is dynamic, which allows you to do things to it that you weren't able to do before, right? In order for two things to happen, one being in order for BNP to actually serve the plan, and in order for the plan not to be modified by the trustee or any other creditor who wants to do it, you have to flatten the plan. It's really, it's a two-click function, right? Craig, please feel free to weigh in here.
Craig, you're doing a great job, Ania.
So flattening, you go up into the corner. Once you've created the plan form, you go to File, Print as an Adobe PDF, and that gives you just a regular PDF form that I think most of us are familiar with, and that is the version of the plan that you need to file.
It removes the interactivity of the form, so you can no longer enter anything in the
right. And to address someone's question that I heard, if for some reason you file a plan and your plan is not flattened, you will receive notice from the clerk's office, specifically from the supervisor saying, you filed a plan, your plan's not flattened, we're not going to serve it. We've gone back, we flattened it for you, but we're not going to serve it for you. And that's the current procedure.
I wanted to mention one other thing, too, is that the court is, different chambers are handling deficiencies regarding service and in your plans in different ways. So you may get an email from chambers. Obviously, if you get an email from chambers, I recommend that you respond to it promptly. Or there may just be a docket entry that shows, you may get a notice from ECF notice showing that there is a deficient notice. And I think Judge Bonsall's court it even shows up on the calendar as a docket, as part of the matter. Just make sure you're paying attention to that. and responding. And Milton, you had a question?
Yeah, just to make things super simple, and I like to get super simple, is that what you do is that don't save it, because your instinct is just to save it or save as. Don't do that. Print it. It's just like you got something that you pull down on paper, you hit your print button, and it goes back. That's what Slack means. You got to just get saved and it gets printed again, so it can't be changed.
But print it as a PDF.
Print it as a PDF, right. Don't save it.
Yes, sir.
I'm sorry. If you don't save it, you print it to a PDF, you're going to turn it into an image. That didn't edit later.
That's right. So we're working.
You save it twice. You save it as a PDF, so if you have to make changes, you can actually go in and change it. But you want to print it to a PDF, and you turn it into an image. That's what it's called.
There you go.
That sounds great.
Young mind.
All right.
Well,
Rod?
yeah, we can take one more question.
Creditor served on your 7004, let's say the initial plan, and you filed a EMS. And if you amend that plan and don't change the treatment to that creditor, you need to file a subsequent.
No, I don't believe that you have to serve them under 7004 again unless you materially and adversely affect their treatment. They just are on the regular certificate of service, and they get notice of it, unless one of the judges disagrees with me.
Well, I know that there may be some other pending questions out there, and we'll note that the Business Bar Committee is working to make a process to make your questions, concerns about the plan easier to get resolved. So stay tuned for more information on that. If you came in after we started, please be sure to see Dale in the red coat over there to sign in. And if you want credit for one general CLE hour, that is available for $5. You can give that to Dale today, or she will also be at 341 meeting on Thursday. And as final note, that presentation materials, as well as a recording of this presentation, will be available on the court's website. So please feel free to visit that if you want a refresher on any of these. And please join me in thanking our panelists.
Thanks, everyone.